Dear learners, we shall be starting with the topic Dissolution of Partnership Firm. So, in our previous lectures on the partnership law, we have discussed how the partnership firm and the agreement it comes into existence, how it functions, how it runs, how the business is conducted, what are the relationship between the partners, so on and so forth. So dissolution of partnership firm essentially is the endness of the firm, or how the life of the partnership business moves towards its end. So looking at the legal framework of dissolution of a firm, it is contained in Chapter 6 of the Indian Partnership Act from Section 39 to Section 55. It provides what is a dissolution, what are the various modes by which a firm may be dissolved, what are the rights and obligations of the parties during the process of dissolution of the firm, and after that, how the assets have to be disposed of, so on and so forth. So section 39 of this chapter talks about dissolution of a firm, and it defines what is meant by dissolution of a firm. Then section 40 discusses how a firm may be dissolved through an agreement between the partners. Section 41 discusses certain situations where the firm has to be compulsorily dissolved. Section 42, the dissolution of a firm on happening of certain contingencies. Section 43, dissolution of a firm by notice or prior information by one or more partners. Section 44, dissolution by a court of law. Section 45, what are the liabilities of parties after dissolution. Section 46, what are the rights of partners to wind up. Section 47, continuing authority of partners for the purposes of winding up. Section 48, what is the mode of settlement of accounts of the firm. Section 49, payment of firm debts. Section 50, personal profits which are earned after dissolution. Section 51, return of premium on premature dissolution. Section 52, rights where partnership is dissolved for fraud. Section 53, right to refrain from using firm name or property during the course of dissolution and after it. Section 54, agreements in restraint of trade. Section 55, sale of goodwill of the partnership firm after dissolution. So it defines how the partnership firm is dissolved, what is the process of dissolution, what are the rights and obligations of the parties, and some connected matters. So our discussion over the two lectures on dissolution of a partnership firm would be a discussion of most of these provisions which are produced here for your reference under chapter 6. Now, first let us take up what is the meaning of dissolution of partnership firm. So essentially speaking, the word dissolution, it in a general sense, it implies breaking up of any constituted body of persons. So as we know that partnership is a amalgamation or a accumulation or a collection of many persons who come together in order to carry on business for the purposes of profits. They also bind each other in the relationship of mutual agency. So as a collective body, as a plural body, as a body of many persons, so formation is signified by coming together, and dissolution is coming apart. So initially those who come together run the business, carry on the business, and then for some reason or the other they fall apart. This is what is referred to as dissolution. Now section 39 defines what is dissolution of a firm. It says dissolution of partnership between all the partners of a firm is called the dissolution of the firm. So what is important here is the word all. So it is like all the partners, they are on board to end the life of the partnership business. Now, generally speaking, dissolution refers to a discontinuation of mutual relations between all the partners of the firm and is a termination of partnership between each and every partner. If there is a discontinuation of mutual relations between only some of the partners, it may not always lead to a dissolution of firm, in which case it is referred to as dissolution of partnership between some partners and not of dissolution of a firm. So you have to distinguish between the two expressions. One is dissolution of firm, which is between all the partners, and the other is dissolution of partnership, which is between some of the partners. So what is the difference between dissolution of a firm and dissolution of a partnership? We will take it up in the part 2 lecture on dissolution of partnership firm. So what happens immediately after dissolution of firm, or what are the effects of dissolution of firm? First is that the business of the firm is completely stopped. So all its operations, all its transactions, all its business activities, they are brought to a complete halt. Second, that whatever assets the partnership firm has, which are being used for the business, they are realized, meaning thereby they are liquidated. Third, from this realization of assets, the liabilities are paid off. So liabilities may be of the creditors of the business of the partnership firm. After that, surplus, if any, which is left after the realization of assets and payment of liabilities, if something is left, it is to be distributed among the partners according to their share in the property of the firm. So it may be in terms of capital, or it may be in terms of some other physical assets. So all in all, the partnership is given what we call as a complete. Now, what are the modes of dissolution of a partnership firm? So firstly, a partnership may be brought to an end by an agreement between all the partners. Secondly, through compulsory dissolution. Now both are juxtaposed to each other. So by compulsorily means that there is no scope of any agreement or disagreement. So there are certain situations which occur because of which the firm has to be mandatorily dissolved, and it cannot be negatived by a contrary intention between the partners, which is not to bring a firm to an end. The third is on happening of certain contingencies or certain situations or state of affairs because of which the firm has to be brought to an end. Fourth is by notice by one or more of the partners to the other partners of the intention to bring the partnership firm to an end. This happens in case of partnership at will. Fifthly, by the court of law. So essentially speaking, if the partners themselves are not able to come to a conclusion that the firm has to come to an end, and if any of the provisions which are attracted to the other four modes, they are not attracted, then there is a provision under the Indian Partnership Act under which a firm may be dissolved by a court of law. Generally, it happens in situations where the nature of the differences or disputes between or amongst partners are of such a nature which are irreconcilable. Now we will discuss each of these modes in some detail, beginning with a dissolution by an agreement. It is defined in section 40. It reads as, a firm may be dissolved with the consent of all the partners or in accordance with a contract between the partners. So this is a very simple and a straightforward way of dissolution of a firm. Section 40 contemplates two ways by which a firm may be dissolved. Firstly, with the consent of all the partners. So here there has to be what we call as a unanimity and not only a majority. And the second is through a contract between the partners. So if there is any provision under the partnership deed stipulating the situations or conditions under which a firm may be dissolved, and if those situations they are realized or they happen, then a firm is dissolved in accordance with a contract between the partners. So this is a very simple way of dissolution, and generally under this mode of dissolution, all the partners, they are on board, they are on the same page, there is an agreement between them and not much dispute. The second is compulsory dissolution, which is provided under section 41. So section 41 reads as, a firm is dissolved firstly by adjudication of all the partners or of all the partners but one as insolvent, and secondly by the happening of any event which makes it unlawful for the business of the firm to be carried on or for the partners to carry it on in partnership. So section 41 essentially talks about compulsory dissolution of a firm under two situations. Firstly, insolvency. Under insolvency, the situation which have to be met are as follows, where all the partners are adjudicated as insolvent, and secondly, of all the partners but one as insolvent. So if any one partner remains, then the firm cannot be carried on because a minimum of two members are required to carry on the business of a partnership firm. Now, by insolvency, we mean the state of being unable to pay the debts by any person or the partnership firm on the date of their maturity. Those who are in the state of insolvency are said to be insolvent. There can be many kinds of insolvency, like cash flow insolvency or balance sheet insolvency. The second is happening of an unlawful event. So if the nature of the business of the partnership firm initially when it was formed, it was lawful, but due to operation of law it subsequently becomes unlawful, then it can lead to compulsory dissolution of the partnership firm. Now we will see an example where the firm may be compulsorily dissolved on the happening of a certain contingency. So we have an example. A partnership firm is doing a business of trading in liquor. After some time and after the partnership firm is formed and after it has carried on the business, a law is passed by which the business of trading in liquor is prohibited. So many states in India have a law prohibiting the trading and sale or purchase of liquor. So in this case, the business of the firm becomes illegal because the subject matter of its business and trade has been declared to be illegal by a law. And so in this case, the firm will have to be compulsorily dissolved. So as this is by operation of a higher law, so this compulsory dissolution, the nature is such that it cannot be varied by a contrary agreement between the partners. So the partners in this case, for example, cannot have a provision under the deed which says that on any law which declares the trading of liquor as illegal, the firm will not be dissolved. Then there is a proviso to section 41 which creates some respite for the partnership firms in cases where the firm is engaged in the business of multiple adventures. So this provision reads as, provided that where more than one separate adventure or undertaking is carried on by the firm, so for example multiple adventures, the illegality of one or more shall not of itself cause the dissolution of the firm in respect of its remaining lawful adventures and undertakings. So what this provision contemplates is that a firm has multiple adventures and those multiple adventures are independent of each other, and the illegality is only with respect to any particular adventure or part of the business, and the nature of the business is that if it is in many parts, it is severable into many parts, or it can be segregated. So let us examine this proviso with the help of an example. A partnership firm is doing a business of trading in liquor and cement. So we have two different kinds of business operations of two different commodities. One is liquor, the other is cement. After some time, a law is passed by which the business of trading in liquor is prohibited. So in this case, the business of the firm related to liquor becomes illegal. However, the business of cement is legal. So here, the firm need not be compulsorily dissolved. But what is important is, as I said, a partnership firm should have multiple businesses or more than one, and each one of them should be severable from each other in its nature and type. The third kind of a dissolution that we are going to discuss is dissolution on contingencies, which is provided under section 42. Now, within this mode of dissolution by contingencies, there are various ways in which how section 42 may be triggered. So if the firm is for a fixed period, let's say a period of 5 years or a period of 10 years, then after the expiration of the partnership term, the partnership firm is ended. Secondly, on completion of any undertaking or adventure, so if the partnership firm has been formed for the purposes of undertaking and completing certain undertakings, adventures or projects, then after its completion, the firm is dissolved. The third is on the death of a partner. And fourth, in case of insolvency of a particular partner. However, the nature of this provision is that this is default in nature. So it is subject to contract between the partners. So it is open to the partners to provide a stipulation in the partnership agreement negativing the dissolution of the firm on happening of certain contingencies. So for example, if a partnership firm has 5 partners and one of the partner dies, so if the partnership agreement is silent as to what will happen if one of the partner dies, then section 42 is triggered. However, if the partners provide under the partnership agreement that on the death of a partner amongst the 5 partners, the partnership will not be dissolved, then section 42 will not be triggered. Similarly, exclusionary clause or negative clauses can be had for other modes like expiration of the partnership term, where a partnership may continue even after this term, or after the completion of undertakings, adventures or projects for which the partnership was formed, and insolvency of a partner. The fourth kind of a dissolution that we are going to discuss is dissolution by notice. This is provided under section 43, which reads as dissolution by notice of partnership at will. So this provision is applicable to those partnerships which are partnerships at will. Now, what is a partnership at will? We have already discussed under the various kinds of partnerships, but to reproduce here for your recollection, it is provided under section 7, which reads as, where no provision is made by contract between the partners for the duration of their partnership or for the determination of their partnership, the partnership is called as partnership at will. So it can be ended at any time by one of the partners, but what is required is that any partner giving notice in writing to all the partners of his intention to dissolve the firm. So this is a very risky provision have for the partnership firm in partnership at will, because any partner may dissolve the firm by giving notice for whatever reason. And so generally this is for very small businesses or side businesses of the partners, because here there is a possibility that in case of any dispute between the partners, it will be immediately dissolved by a partner by giving a notice. The fifth kind of a dissolution is dissolution by court, which is given under section 44. Now this is a kind of a extraordinary mode, because it is generally triggered when the nature of the dispute is irreconcilable and partners cannot agree upon any compromise on the basis of which the business of the firm may be continued to be carried on. So the dispute is between the partners. Now some of the partners want the dissolution and others do not. So the matters have escalated to such an effect that it is no longer in the hands of partners and they cannot be resolved by the partners between themselves. So they go to a third party, which is a court, a dispute resolution mechanism, in order to dissolve the firm. Now who approaches the court? It is the partner who wants the dissolution. And who is at the opposite end? It is the partner or partners who do not want the dissolution. Now the nature of section 44 is that it cannot be made subject to contract between the partners. So it is compulsory in nature and it is therefore a hard law, because no exclusion or variation can be made by the parties in the partnership deed. So parties in the partnership deed cannot provide that there will not be a dissolution by court. The nature of the relief here that can be given by the court is discretionary in nature, because the language of section 44 provides at the suit of a partner, the court may dissolve the firm on certain grounds. So this is something that is discretionary and is exercised by the court in extraordinary situations. Now, what are the grounds for dissolution of a firm by a court? They are provided under section 44, a rather detailed clause. So if we have to break it down for you, then following grounds are mentioned under section 44 for dissolution of a firm by a court. First is unsoundness of mind of the partner. Second, permanent incapacity of a partner to perform any duties. Third, any conduct by a partner which is injurious to the partnership business. Fourthly, if a partner indulges in continuous or persistent breach of partnership agreement. Fifthly, if a partner transfer whole of interest to a third party. Sixthly, when business can be carried on only at a loss, so it is not possible to carry on the business for profit, which is an essential for a partnership business to survive. And lastly, just and equitable grounds, or this is a residuary clause, So if there is no ground which is provided by the language of the statute, but if a situation has come up in which the court feels that it is just and equitable to dissolve the firm, then the firm can be dissolved on just and equitable grounds. So we've discussed what is its meaning, what are its effects, what happens immediately after the firm is dissolved. We've also looked at the legal framework for dissolution of partnership firm. Then we had an overview of the various modes of dissolution of a firm. So we have discussed by agreement, compulsory dissolution, on happening of certain contingencies, by notice, and we have listed the grounds on which the firm may be dissolved by the court. With this, we end this lecture. Thank you very much.